Today I wanted to talk about negligence law and in the context of motor vehicle accidents. Hi, I'm attorney Pedro-Juarez. I'm an attorney here in Boston, Massachusetts. My practice area is personal injury with a focus on motor vehicle accidents. Okay, so how do you prove liability in motor vehicle crashes? Obviously, establishing fault is going to be key for you to get paid in your injury claim. There are four elements to prove negligence, and it's always the plaintiff that bears the burden to prove by a preponderance of the evidence, meaning that it's more likely than not the case or more likely than not true. That's the standard that the plaintiff has to meet. Think of it as a balancing act, like you have to tip the scales in your favor that these elements were established or proven in order to get compensated in a claim. The four elements are duty of care, a breach of that duty, causation, and damages. And I'll go into it in more detail next. Okay, duty of care. Massachusetts requires motorists using roads to use a reasonable amount of care for their own safety and that for the safety of others, such as passengers, other motorists, and pedestrians. An operator of a motor vehicle must exercise reasonable care under those circumstances. And reasonable care just means the care of an ordinary person, ordinary and prudent person would exercise for that situation. And obviously, the greater the danger, the greater duty of care that person should exercise. Um, a driver of a motor vehicle owes a duty of reasonable care at all times to avoid placing themselves or others in danger. We can obviously imagine that driving a motor vehicle is probably not the dangerous thing, but it is relatively dangerous as people can get seriously hurt, even killed, if you're careless or not paying attention while you're driving the car. Okay, the second element, breach of that duty. The plaintiff must show or establish by a preponderance of the evidence that a defendant in operating the motor vehicle failed to exercise due care or reasonable care. That means that you have to show that the defendant was careless in their operation or maintenance of the car. The third element is causation, and that's when the defendant's negligent conduct or acts caused or worsened the plaintiff's injuries. So even if the defendant is found negligent, the defendant is not liable to the plaintiff unless the defendant's negligence caused the harm as well. And there are two prongs to this element. You have factual causation and you have legal causation. Factual causation is this but-for test. So meaning that to meet this burden, the plaintiff must show that the harm was more likely due to the causes for which the defendant was responsible, rather than some other reason, other cause. The plaintiff must show that the defendant's negligence was necessary to bring about the harm. So essentially, had it not been for this act or this omission, the accident or the harm would not have happened. The second test is this legal causation, and that's a foreseeability argument, which states that the plaintiff must also show that the harm was reasonably foreseeable to a person in the defendant's position at the time of the negligence or the act. The plaintiff doesn't have to show that the defendant foresaw it completely or in the exact manner, but it has to show that the harm was a natural and probable consequence of that act or negligence. Okay, lastly, we have damages. The purpose of giving somebody damages is to compensate an injured person for the losses they incurred because of the negligent act. The goal is to restore the plaintiff to the position they were prior to the accident or had the accident not occurred. It's not really to reward the plaintiff or to even punish the defendant. Punishment is dealt in the criminal context. This is a civil action, So it's really to make the plaintiff whole again. And the damages that are awarded to the plaintiff is a fair and reasonable compensation for the harm done to them. Uh, I will stress that there's no special formula to assess the damages for the plaintiff. The law doesn't require the plaintiff to prove their damages with any mathematical formula. The jury ultimately, if it goes to trial, the jury ultimately decides what is fair, adequate, and just. The jury will use their own sense of justice and try to translate that into dollars. Uh, I'll just a side note here. Typically, what the jury looks for is the amount of special damages, meaning they add up all your expenses and lost wages, and they apply a multiplier. Often it'll be 2 or 3 times that amount. It might be as high as 5 times that amount. It really obviously depends on the severity of the injury or the harm and how much medical bills there are in lost wages. And with that, just there's two broad categories for damages. You have your economic damages and you have your non-economic damages. Economic damages, as I mentioned, is for the tangible stuff such as medical expenses, loss of earning capacity or lost wages, and any replacement services. Your non-economic damages, that's for your pain and suffering, both for your mental and physical pain and suffering, past pain and suffering, and future pain and suffering, as well as any type of loss of enjoyment or loss of consortium claims. Comparative negligence. Now, comparative negligence is a defense for the defendant. So in Massachusetts, there is a defense to this. It's called comparative negligence. And the defendant instead of the plaintiff, now has the burden. So the burden shifts to the defendant to prove this defense. And it's the same standard. The defense needs to prove it by a preponderance of the evidence. So it's more likely than not that this is true. So this just simply means that if the defendant is deemed to be negligent and the defendant's negligence caused the injuries, there's also a question that needs to be addressed whether the plaintiff um, also caused or contributed to the accident or to his or her injuries. So to show this, the jury is going to have to decide what percentage the plaintiff and the defendant were at fault, and it needs to equal 100%. But it is important to know that in order for the plaintiff to recover, um, the plaintiff needs to show that the defendant was at least 50% at fault or more for the accident. If the jury comes back and determines that the plaintiff was 51% at fault for the accident, then they are barred from recovery, meaning that they can't recover for their claim. If it's 50-50, equally, they both parties equally contributed to the accident, then they could recover 50% of that claim or of that damage. Um, but it could also be a percentage of that. For example, it could be 70, 75, 25, or 60-40, or 90-10, whatever they're able to establish at court or agree to prior to going to suit or going to trial. But the key is there that they have to show that the plaintiff needs to show that defendant at least proved at least is 50% at fault for the accident or more. So, what type of evidence do you need in order to show this? Um, Naturally, you may need a police report. Police reports often will describe witness statements, driver statements, issue any citations. They'll make their own observations from what they saw after the crash. You might need witness statements, people that were not inside the cars, but maybe were bystanders or occupants in other cars that saw what happened. It's also a good idea to um, check if there's any traffic cameras, if there's any CCTV, if either at major intersections there might be um, some town or city video cameras. But there also might be cameras at a nearby gas station or at a store. Also, again, it's important to talk to witnesses because maybe the witnesses may have a dash cam, or the drivers themselves might actually carry a dash cam. The statements of the drivers themselves. These are called admissions. So the drivers might admit to what happened in the accident, and that serves as evidence of its own. Uh, Also, scene evidence. So right after the accident, it's important to take pictures if you notice any skid marks. Take pictures of the vehicle positions and any damaged property that might have been left over. Also, you want to take pictures if you're injured. If you want to take pictures of your physical injuries, pictures of the damage to your car, and the scene of where it happened, just to get orient yourself or try to show that to the adjuster or to the attorney as to where exactly it happened. But if it does go to suit or trial, then you might need some expert testimony. You might need an accident reconstructionist. You might need a biomechanical expert to determine that the injury is related to the accident or to show the mechanism of the injury. You might need a medical expert, either your own treating physician or an independent medical exam, to again correlate the injury to the accident. If you're severely injured and you can't go back to your job or you can't go back to your regular duties, then you may need to hire a vocational rehab expert to try to figure out what jobs you are able to perform, or what jobs are available for you to perform. You also may need an economist to figure out how much you've lost from work, or how much this is going to impact your life, um, and hopefully that's not the case, but it does happen, or you may need an economist in some situations. All right, final thoughts. Just remember that after a crash, try to collect as much evidence as possible immediately following the accident and try to save that information. Try to get a hold of any witnesses, take pictures, videos, make sure you save all this information. Right after the accident, try to fill out your crash report or write out a statement, because you know memories fade, people move, video gets lost. So it's important to save this information for posterity. And again, hopefully it's not the case, but if it does need to go to trial, you're going to need that for evidence. Um, Please note that this is not intended to be legal advice, and this is not meant to create any type of attorney-client privilege. This is just for educational purposes. If you do need an attorney, please consult an attorney, a licensed attorney in your state or jurisdiction. If you'd like to reach out to me, feel free to send me an email or book an appointment. Happy to talk to you about your situation. Thank you.